For Creamer Media's Polity, I'm Shannon de Rehove. I'm speaking to Bowman Gilfillan corporate law partner Carl Steyn on the implications of the new Companies Act on business owners. Welcome to the studio.
Thanks for having me.
Carl, the new act reflects a profound philosophical shift in the way we understand the relationship between companies and the broader society.
Yes.
In the wake of the Enron scandal, it has been seen that there's a growing global awareness of companies' effects on the economy.
Yes.
Why do you say this?
Well, there's empirical evidence that more than 50% of the turnover or revenues earned globally by everyone and sundry on this planet are in fact owned by companies, not by governments. So that's an astounding fact, and it's indicative of the fact that companies are today an integral part of society. They have become as integrated into society only over the past 30 odd years or so. But today, society simply cannot function without them. So the days of the company being this vehicle which is used by an individual or group of individuals to earn as much money as possible for their shareholders, those days are now gone. Companies are now responsible to many people other than their shareholders. This includes their employees, the environment in which they function. Think of companies which produce massive pollution, for example, as well as the communities in which their operations find themselves. In other cases, even the society as a whole is affected by a company. Another example I can give you are stock exchanges. Today, literally trillions of dollars are channeled into companies on a minute-by-minute basis through the medium of stock exchanges. The money that you deposit in your bank account is in fact deposited with a company. The parking ticket I collect when I park in a building and then pay for is in fact a parking ticket issued by and paid to a company. So companies are, whether we like it or not, integral to our everyday lives, and therefore the new Companies Act has been forced to reflect that very fact.
Now, the new Companies Act grants new rights and remedies to a range of stakeholders, including employees, creditors, suppliers, and minority shareholders.
Yes.
Can you tell us more about these and how they differ from the old Act?
Okay, that's quite an interesting point, because the old Act, and when I say the old Act, I'm going way back to 1974. Now, a lot has changed in the 40 odd years since then. The old Act was in fact a purely capitalistic piece of legislation, by which I meant it was structured on the basis that a company was there for the sole reason, well, not the sole reason, but for the primary reason of making as much money as it could for its shareholders. The Act itself therefore gave very, very few rights indeed to the company's other stakeholders, such as its employees. In fact, I don't think employees had any rights under the old Act at all. Certainly trade unions didn't. Certainly the old Act had no regard for the environment, for example. The new Act therefore starts off a very, very low base, or what I call a zero base, when it comes to stakeholders' rights, because there were no rights before. The Act, some people say, goes to the other extreme. As they say in the classics, the pendulum may have swung to the other side, because under the new Act, stakeholders have very, very significant rights indeed. And those rights extend to employees as well as trade unions and suppliers and customers and anyone, in fact, who is affected by a company's operations.
Now, you've touched on the trade unions, and you say it encourages stakeholder activism.
Yeah.
What is the particular focus on trade unions?
Well, the most important, there are a number of sections of the Act which give rights to trade unions. Or a trade union is just an employee representative. So call it to the employee representatives are given significant rights. I would say the most significant right of all that they are given is what they call the class action. Now, the class action has gained notoriety because of its use in the United States as a means of enabling thousands of people who have a common complaint against a company to gain access to the courts and have the courts hear their case as a class or a group of persons. Now, trade unions represent a class of persons, being workers, and the Act specifically permits trade unions to bring class actions, which means that the body of employees of a large company, now if they have a common complaint against the company, such as a wage demand or improper working conditions, can now as a class, through their trade unions, bring an action against the company, which means they don't have to find the money to access the courts. So money no longer becomes that much of a problem for them.
I suppose an example of that would be the mine silicosis problems that are going on.
Yes, indeed. Yes, indeed. To give you a business example, you may recall that a couple of years ago, Telkom, unbundled its shareholding in Vodacom, and the unions objected to it. You may recall the unions went to court and even went to the Constitutional Court. The Companies Act didn't have a class action in those days. Had the class action existed then, in my opinion, the unions would have succeeded in blocking that transaction. So it has the whole question of stakeholder activism under the new Act, in my view, in time to come, will become really part of daily life, and rightly so.
Do you think that's to the benefit or the detriment of the company?
I don't think it's a question of detriment or benefit. I think it's a question of a company's responsibility to society. Companies have to behave as good corporate citizens. They have a duty to do so. If they do not, then their actions can have profound negative effects on an entire economy. I look at the actions of the United States banks in recent years, for example. Banks are companies. They literally brought the economy of this world to its knees, nearly destroyed the economies of this world. Why? Because they did not properly discharge their duties to their depositors and society as a whole. So, like you and I, a company is a person in law and must behave properly. If it doesn't, it must suffer the consequences.
Now, it is said that the Act is a genuinely revolutionary piece of legislation. Can you elaborate on that?
Firstly, I must say that there are profound changes to the old legislation. The old legislation is 40 years old. Just think, ponder for a moment what has happened in 40 years.
10 years even.
10 years, exactly. I mean, think of the telecommunications revolution. Think of the ease of global travel and the transportation of goods and the exponential increase in cross-border transactions. So the Act has to adapt to the dynamics of business. And unfortunately, or fortunately, depending on where you stand philosophically, business changes very, very rapidly and continues to change more rapidly every day. The law must adapt to business change. Business change cannot be expected to adapt to the law. So there have been a number of significant changes to our laws. The whole question of the new philosophical approach that a company owes its duty to all its stakeholders and society as a whole is a profound change, because the old Act was a purely capitalistic model which said the shareholder make as much money for the shareholders as possible. Another profound change is that they have decided to scrap the closed corporation, the small business vehicle clause called the closed corporation. In future, new closed corporations are forbidden. Now, closed corporations outnumber companies by something like 8 to 1. So closed corporations have been an undoubted, indisputable success. Yet government has decided that in the interests of uniformity, they don't want different types of what they call limited liability entities. They'd rather have one. So they've decided to effectively do away with a closed corporation and replace it with a new small company, which the Act structures in a manner which I don't have the time to go into now, but which has a profound and significant impact on the manner in which company law is structured, particularly in relation to the powers of shareholders and directors, because closed corporations do not have shareholders and directors. They have only one person who's all-powerful called a member. Also, a closed corporation didn't issue shares, whereas companies issue shares. Another significant change is the introduction of the new business rescue remedy. You may have heard of that as an alternative to what they call last resort liquidation, where a company is in financial difficulty and it may be possible to save the company or at least ensure that creditors get a better return than they would have got on liquidation. So we have this new business rescue procedure, which is modelled on the notorious Chapter 11 of the United States Bankruptcy Code.
I thought it sounded familiar. Is it?
Yes, correct. We also have all the new stakeholder remedies, which are extremely important and will obviously have a significant effect, in my view, on the entire litigation industry in this country. And I could list at least 4 or 5 other profound changes if you'd like me to.
If you've got time for that,
Yeah, sure. The Act is written in modern English. In fact, there's a section of the Act which says that every public document that is ever published must be written in plain English so that the man in the street can understand it.
Thumbs up to that, yes?
Yeah, agreed. The Act, I'm all in favour of the Act. I think it is absolutely essential. I believe it is the most important piece of business legislation that this country has produced since the turn of the century. It introduces simpler administrative and regulatory procedures. It enables companies to be formed and administered far, far more easily. In fact, government has specifically stated that it is every South African citizen's constitutional right of freedom of expression. I'm not a constitutional lawyer, so don't push me on that one, to form a company. The freedom of expression is illustrated in the use of company names. In the past, the registrar of companies had the right to refuse to register a name if, in his opinion or her opinion, it was undesirable. All changed now. The registrar, or now called the commission, is obliged to register a name unless it is confusingly similar to another name or incites racial hatred or something like that. So there's been a profound philosophical change there. The Act has also introduced far greater requirements in respect of accountability and transparency and what they call corporate governance. Because of the abuse mainly by multinational companies of the likes of Enron at the turn of the century. Regulators have become far more aggressive towards directors of companies who do not properly discharge their duties. And part and parcel of the aggression has been the demand of far greater transparency in their annual financial statements and of disclosure of their various activities. They have introduced, for example, what they call integrated accounting, where public companies are no longer required just to produce a set of figures. They are obliged to produce what they call integrated reporting. That is, how the company how the operations of the company affect the society and the communities in which they operate, as well as their employees. The disclosure requirements of various companies, not only in relation to their actual operations, but also in relation to their shareholders, for example, who they are, what they are, whether they're from other countries, etc., are now, those sort of disclosures are now obligatory. So I suppose I could sum it up by saying that the so-called corporate veil, which people have in the past been able to hide behind, has been lifted substantially, and in many, many cases even pierced, so that recalcitrant directors, for example, cannot hide behind the protection of the limited liability of a company if they do not do their jobs properly. If they do their jobs properly, then there's no change. People seem to feel that directors are now under more threat of personal liability. That is not true. They are only under greater threat of personal liability if they do not discharge their duties properly. So I think the balance between greater director accountability and the fact that companies are there to take risk, because that's what business is about, risk. And it's not easy to achieve that balance. I think the Act probably does so, but only time will tell.
Well, thank you so much for your insight. It was fascinating
You're welcome.
to speak to you.
Thank you.
That was Carl Steyn, corporate law partner at Bowman Gilfillan, discussing the new Companies Act.